All right, good morning, good morning. This is a really quick emergency. All right, hang on. Let me get Sprinkled on up here, and we're going to be talking about the monster. It's unbelievable. Okay, okay. Let me tell her to look over there. Hang on. Sprinkle donut. Okay, Sprinkle. Hang on. Hang on a minute, guys. I got to get Sprinkle to come up first. Just give me a minute. This is an emergency. It just happened. Uh, I need to get her let me see if I can get her anyway. Yes, emergency. It has just happened. We are in shock. I'm very upset. I feel so bad for all the people involved, and I will never understand how this happened. So let me get this over to Sprinkle Donut just a moment here, about something. Okay, wait a minute. Upcoming, is it going to show? Oh, here we go. Here we go. Let me see. No, no, no. Stop. I gotta get the link to bring up my friend. Hang on a minute. Okay, guys. Invite a guest. Here we go. Copy. All right. Let me get this to her and we will be going. Paste. Paste. There we go. All right. So we're going to get sprinkled on up in here. I just sent it. I just sent the link. Here you go. I just sent it to you. Sorry. Once we get up here, we can start talking and we'll be pulling these things up. This is new news. It just happened. The notice just came out. So let me get sprinkled up here. Okay, look on your phone, baby. Look on your phone. All right, I just texted it. Sprinkle, I just texted it to you, honey. Mm. Yeah, I wasn't prepared to go live today. I didn't even think I was going to because, we're trying to get ready to go somewhere. But yeah, this is we have to talk about this. We have to talk about it. Check your phone, honey. Check your phone. Let me let her know. Check your phone. Okay, come on. There she is. All right. Add to this. There's my friend. All right. There we go. There we are. All right. Let's talk about it. Unbelievable. The damn monster wins a new trial. I was afraid this was going to happen, and I'll tell you why. Because I've seen it happen in a different trial, but over a juror, sort of like this. I don't know the name of it right now. I'll have to pull it back up. But when I saw it, I was like, oh my God, I know it's going to happen. And I fear that Murdaugh is going to get a new trial too, to be honest with you. Anyway, go ahead, Sprinkle. Tell us what you know. Mhm. Okay, so let me pull it up over here and we'll try to get it online. Letitia Stouch. All right, let's see what it says. Colorado court overturns Stouch's murder conviction. Here it is, guys. Now I'm going to try to share my screen. Hold on a second while we talk about this. I'm so upset. I'm so worried about that family. It's so unfair. So let's share this right quick. I mean, can you? No, you got a call for this. Oh, no, no, no. Don't you make me do that. Allow. Okay, no, I don't want to do that. No, return to the home page. No, I don't want to do that. It didn't propose. All right, let me go pull it up from Colorado courts. Here we go. Okay. Letitia. Letitia the monster. I can't stand it. I don't. What has happened? Oh yeah, of course she is. All right, here we go. Okay, so let me share it with this one instead of that one because okay, let's share a different screen. Hang on a minute, guys. I want to be able to read this. Let's share the other one. Right, I think I can use this one instead because I didn't want to have to pay to. Okay, this is going to be from I think it's Colorado. What is this? KKTV.com. Full credit to KKTV.com. Here we go. Whoops, let me put this in here. When you're in a hurry, of course, you make all kinds of mistakes. All right, let's put this up here for fair use. We're going to talk about fair use through it. All this information is being shared under fair use through the Fair Use Act. So let's just go ahead and let y'all know that. Now, I'm going to pull this up and read it for a second. Here we go. Juror related to DA office employee, defense challenged the juror and appeal attorney's reversal. Colorado Springs, the conviction of a woman, an El Paso County juror found guilty of murder in the death of her stepson, 11-year-old Gannon Stouch, has been overturned and she will be retried. I'm so sorry to hear this. I am hurt for the mother. I'm hurt for the father. I'm hurt for the whole family. How dare this bitch think that she deserved a new trial after she admitted what she did? Let's see what it says. In the opinion released by the Colorado Court of Appeals Thursday morning, the court said Letitia Stout's conviction must be reversed after the majority found that the trial court committed an error by denying the challenge related to a biased juror and a new trial must be held. Unbelievable. You see, okay, look down. Me, um, I don't remember now. Well, let's read this. Read this. A division of the Court of Appeals considers whether an erroneously denied challenge for cause is waived or invited. Or invited by virtue of the fact that the defendant does not use a preemptory challenge to remove a biased juror to correct the trial's court error. The majority finds neither waiver nor invited error in this context, and applying People versus NABDUL, which we've talked about this case before, concludes that the error warrants a reversal for structural error because of a biased juror deliberating. The dissent concludes that the defendant waived the right to claim error on appeal by exhausting all her preemptory challenges without excusing the biased juror. See, now I've always wondered if this was a situation where the attorneys knew it and they did not do anything because they knew they could win on an appeal to get her an appeal. I always wonder if this was done underhanded like that. So, Philip Weisner, Attorney General, Catherine Gillespie, Senior Assistant Attorney General, and Denver, Colorado for plaintiff appellee, and Eric Sampler, Alternate Defense Counsel, Hollis A. Whitson, Alternate Defense Counsel, and the Denver, Colorado for defendant appellants. Sitting by assignment of the Chief Justice under provisions of Colorado, and then there you go. Now, the defendant, Letitia Stouch, appeals the judgment of conviction entered after a jury found her guilty of the first-degree murder after deliberations, first-degree murder of child under 12 by one in a position of trust, tampering with a deceased body, and tampering with physical evidence, and multiple crimes of violent sentence enhancers. Because we conclude that the trial court committed structural error by denying Stouch's challenge for cause to be a biased juror who deliberated, we reverse the convictions and remand for a new trial. So the prosecution presented evidence at the trial that Stouch brutally murdered her 11-year-old stepson, GS, but put his body in a suitcase and left it under the bridge in Florida. Stouch pled not guilty by reason of insanity, arguing that she suffered from dissociative identity disorder, but the jury rejected the defense and found her guilty as charged. The trial court sentenced Stouch to life imprisonment without the possibility of parole, plus 2 consecutive sentences for tampering with convictions. Now, this is what's weird about this. She admitted guilt by reason of insanity. Are you telling me just because of this juror issue, they could not determine that she was still guilty? I mean, what they were actually talking about was she responsible for it or not, right? I mean, that's really, because when you admit that you've done it, but you think you were temporarily insane, then the trial was really about, was she temporarily insane or did she know what she was doing? That's really what this trial was about. So you're going to tell me this one juror is, oh wow, this is horrible. Ugh. She also asserts that the court erred by denying her request to suppress evidence. Okay, second part of it, suppress evidence obtained pursuant to an overbroad warrant by admitting a certain testimony by her ex-husband. We agree that the court committed structural error when it denied Stouch's challenge for cause and a biased juror deliberated. As a result, her conviction must be reversed. Because it is likely to arise on remand, we also consider and reject Stouch's Fourth Amendment challenge to the search warrant. However, we do not reach the remaining evidentiary issue. So here's the challenges that she made. All right. So Section 16, now there's the reading, provides the trial court shall sustain a challenge for cause on one or more of the following grounds: relationship with the third degree by blood, adoption, or marriage to the defendant or to any attorney of record or attorneys engaged in the trial of the case. The existence of the state-minded juror evincing anonymity biases toward the defendant of the state. Okay, the court is satisfied from the examination of the juror or from other evidence that he will render an impartial verdict according to the law and evidence submitted in the jury to the jury at the trial. Okay, well, that was the instruction. Jurors who fall within one of these categories are considered biased as a matter of law. Okay, completely biased section. Go ahead. Hmm. Right, 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 right. Okay, that remember we watched the oral arguments, and that was discussed at length. So, and that's where we heard about this Nabatambu L, which was this case that they had talked about before, and it was the same kind of a situation. So, they, upon a challenge for cause, the trial court is required to excuse them because, except described in subsection 1J, they cannot be rehabilitated, which is the People versus Nabatu L. So, in People versus McCrander, the Supreme Court held that when an elected district attorney is the attorney of record in section 16-10-103 1B, includes prospective jurors who are related not only to the elite elected district attorney, but also to any deputy district attorney in that office at the time that the jury selection occurs. So then it talks about overruled on other grounds by People versus Novanity in 2014. This is the statute directs automatic removal of a jury related within the third degree to any deputy district attorney and the elected district attorney of record's office, regardless of whether the deputy district attorney appeared or participated in the case. Okay, and then says C, at 242. This preserves the appearance, if not the reality of fairness in a criminal prosecution, and public trust and confidence in a criminal justice system. When a trial court erroneously denies a challenge for cause and a biased juror serves on the jury, the error is structural and requires reversal. As a part of the voir dire, the prospective jurors completed a questionnaire that included a question about whether they had friends or relatives in law enforcement. Prospective juror NB indicated that his son-in-law worked at the El Paso County District Attorney. During the follow-up questionings, juror MB confirmed that his son-in-law worked as a deputy district attorney in the same office as for Michael Allen, the elected district attorney in El Paso County of the prosecuting attorney in this case. The defense counsel later identified juror MB among the prospective jurors he wished to challenge for cause. When the court asked for more details, the defense counsel explained, his son-in-law works for Mr. Allen. The prosecutor and the court then made the following comments. Here's the prosecutor. I hate to agree with the defense counsel, but the follow-up questions were never asked. How is that going to impact his ability to be fair and impartial jurors? And certainly doesn't rise to a level of statutory cause. So we would object to him being released for cause. Then the court says, which is the judge, I love Judge Warner. I'm so upset about this. I'm going to circle back to that one too. probably what I'm going to do is excuse juror MB at this point and this time and think about it over the weekend and see where we are. I tend to agree that I don't think it's a statutory cause. I didn't hear anything else about the fact creating an issue or a conflict or something else. I don't run across these sets of facts very often, so I just need to think about that one, and it may be that I decide next week. Okay. The prosecutor then suggests that the court ask further questions of juror MB, and the court agreed. The defense counsel once again objected. I think the record is what it is. And I guess the only thing I think there is, a difference between somebody saying, I have a son or a daughter who works in the police, then I have a son in law who works for the DA who is actually trying the case. And so I think that's where it becomes different. Even if it was a different district attorney, other than the son in law's direct boss who is trying the case, I think it would be different. And I'll just leave it at that. Okay. So the trial court brought the prospective juror back into the room and asked juror MB how long his son-in-law had worked for the district attorney, whether juror MB had discussed the case with his son-in-law, or whether juror MB might be influenced by a desire to have the case work out better for his son-in-law. Wow, this is wild. Based on his answers, the court instructed juror MB to return the next day. He was not ultimately dismissed. All right. Now, this is when it goes into the discussion. The Attorney General does not dispute that juror MB fell within the category described by Section 16-10-103(1)B because he was related within the third degree to his son-in-law, who was a deputy district attorney in the prosecuting district attorney's office. We are bound by the Supreme Court's determination that his bias was implied by law. Right? Nevertheless, the Attorney General argues that reversal is not warranted because it's not clear from the record whether the juror MB deliberated. But see, we know he did because somebody got excused. The Attorney General also asserts that the defense counsel's challenge for cause was not properly preserved and that the counsel either waived or invited the trial court's error. We are not persuaded by these arguments. But then what happened? MB deliberated. Our review of the record demonstrates that juror MB deliberated. Indeed, the trial court granted Stouch's motion to settle the record on this point, removing any doubt. The challenge is properly before us. The Attorney General's first argued that Stouch failed to properly preserve her challenge for cause because counsel did not explicitly cite Section 16-10-103(1)B and did not correct the trial court's purported misunderstanding that the challenge for cause was based on something other than a statutory ground. The Attorney General further asserts that the defense counsel's comments after making the challenge for cause suggest that the challenge was based on juror MB's actual bias, subject to rehabilitation, not his implied bias based on his relationship to the prosecutor. For the reasons discussed below, we conclude that the court considered and ruled on statutory challenge for cause under Section 16-10-103(1)B. Therefore, the challenge is properly before us. To begin, we recognize the defense's counsel for challenge potentially implicated two different subsections of Section 16-10-103. Recall that the statute requires the court to sustain a challenge for a cause on one or more grounds, including implied bias on a relationship to an attorney of record. Okay, that's in subsection 1B. And actual bias subject to rehabilitation under subsection 1J. That is, defense counsel could have based his challenge on juror MB's relationship to the prosecutor, subsection 1B, or his state of mind resulting from the relationship under section 1J. Given this context, we reach two conclusions from the record. First, we conclude that the counsel's stated reason his son-in-law worked for Mr. Allen was sufficient to trigger a ruling under subsection 1B. Second, even if we're not clear solely from counsel's challenge to juror MB on which part of the statute the counsel was lying, we nevertheless conclude the prosecutors and the court's subsequent comments brought subsection 1B squarely into the play for purpose of our review. It says, see People versus Melendez. Okay, then it goes, this language is not required to preserve arguments for appeal, but the trial court must be presented with the opportunity to rule on the issue. As the prosecutor correctly observed at the time of the challenge, neither attorney had asked any questions to elicit whether juror MB had a state of mind, evincing enmity, or bias. Without these questions, there was no way to tell whether juror MB should be excused for actual bias under Section 16-10 103 1J. Having recognized the prosecutor continued to note that challenge, certainly the ID isn't or rise to the level of statutory cause. In this context, we conclude the prosecutor could only have been referring to statutory cause based on implied bias under subsection 1B. The trial court's subsequent comments likewise suggest its awareness of the distinct for cause challenge available under subsections 1B and 1J. The court first said, I don't think it's a statutory cause, and then noted that it didn't hear anything else about the fact creating an issue or a conflict or something else. These comments indicate a cursory and improper rejection of the challenge based on the relationship under subsection 1B, followed by a separate consideration and rejection of the challenge based on biased state of mind under subsection 1J. Despite the Attorney General's arguments, we do not read these statements as demonstrating confusion about the nature of the defendant's counsel's challenge. Instead, we read the context. We conclude that the trial court statements, I don't think it's a statutory cause, reflects the court's mistaken belief that juror MB's implied bias based on his relationship to the prosecutor, as distinct from his actual bias as a result of the relationship, did not trigger mandatory removal under 16-10-103. In other words, the trial court was not questioning whether the defense counsel was making a statutory challenge for cause based on a relationship itself. Instead, and critically for the purpose of our review, we read the trial court statement as expressing its inclination to deny the challenge for cause on both grounds. When the trial court ruled on the claim raised on appeal, it's properly before us. Defense counsel's subsequent argument that this situation might be different if the juror's son-in-law worked for the police or for a different district attorney other than his direct boss, who is trying this case, does not change the result. As the Attorney General acknowledges, the argument went to whether juror MB should be excused for actual bias under Section 16-10-103 1J, and the trial court had already rejected that challenge under Section 16-10-103 1B. As a result, the defense counsel was under no further obligation to restate his objections, because he had already done that, right? Likewise, the defense counsel did not cite Section 16-10-103 1B as is a no moment. Okay. The Attorney General relies People versus Ceballos Acosta, and anyway, in which a division of this court declined to consider the denial of a challenge for cause because defense counsel did not specifically cite a Section 16-10-103 1K. But in Ceballos Acosta, defense counsel moved to challenge the juror for cause because he would place authority on the testimony of a police officer over anybody else, not based on the mere existence of a relationship covered by the statute. This case is distinguishable. Defense counsel's initial challenge for cause specifically stated that juror MB was related to the prosecutor. Unlike the Ceballos Acosta counsel did not argue that juror MB might have actual bias in favor of the prosecution. And as discussed, even if defense counsel's comments left any doubt, the prosecutor and the trial court expressly acknowledged and dismissed the possibility of a statutory challenge based on the relationship itself. On these facts, we conclude the trial court was on notice of the particular ground for the challenge, even without specific reference to the Section 16-10-103 1B. An argument that goes to the subject matter of a statute without citing the statute directly sufficiently preserves the matter for appeal. All right. Challenge for cause was preserved, even though it was not expressly for cause, because the context made it clear was a challenge for cause. The error was neither waived nor invited. Waiver is the intentional relinquishment of a known right or privilege. We indulge every reasonable presumption against it. Invited error, by contrast, prevents a party from complaining on appeal of an error that the party invited or injected into the case. It is a narrow doctrine and applies to errors in trial strategy, but not to the errors that result from oversight. The The Attorney General asserts that the defense counsel waived or invited the trial court's error by failing to clarify the basis of the challenge after the ruling, suggesting that the court was confused about the grounds for the challenge. But we have already concluded that the trial court's comments did not indicate that it misunderstood the nature of the challenge for cause, only that it did not believe excusal was warranted. Given this reading of the record, the foundation of the Attorney General's waiver invited error arguments collapses. In any event, after Juror MB answered the trial court's follow-up questions, defense counsel said, "I maintain my objections to Juror MB." This ongoing objection suggests that there was no waiver. Nor can we conclude that the defense counsel waived or invited the error by failing to use peremptory challenges to excuse Juror MB. The law does not require a criminal defendant to use peremptory challenges to preserve an unsuccessful challenge for cause. To the contrary, the Supreme Court has held that its prior decisions do not require a defendant to cure a trial judge's error on challenge for cause by using peremptory strikes against objectionable jurors in order to preserve a claim that his right to a fair trial was violated by the presence of the biased juror. Damn. Okay, so the holding in Morrison, which is a different case, indicates that there is no inherent inconsistency in allowing counsel to challenge a juror for cause while also permitting her to use peremptory challenges to excuse other jurors. We recognize that the majority in Abu Natumbo L, which we've talked about many times, declined to consider whether waiver or invited error might apply in such a situation because it was not raised on appeal. Okay. Nevertheless, the majority suggests, albeit in dicta, that even if it were to entertain an invited error argument, it would find no invited error because the record did not suggest that the defense counsel purposely failed to use a peremptory challenge to remove the impliedly biased juror. Similarly, we see no suggested invited error here. And particularly in light of the defense counsel's ongoing objection, we see no suggestion of waiver in record. Boy, the Attorney General relies on Justice Zamora's dissent in Abu Nabatu L, expressing the defense counsel's decision not to use a peremptory challenge to excuse a juror after the loss of a for-cause challenge is a classic example of waiver or invited error. Zamora J. dissenting. Like Justice Zamora, the Attorney General suggests the counsel may simply request and the trial courts may encourage to grant an additional peremptory challenge. But as in Abu Natumbo L, the record here lacks any indication that the defense counsel was acting strategically. So in other words, what we've tried to accuse them of, they're saying that's not what happened. Like they didn't intentionally do this so they could win a new trial. That's what they're saying. Additionally, we are not persuaded that the defense counsel should be required to use peremptory challenges to excuse that biased juror after the court erroneously denies a for-cause challenge. Moreover, nothing prevents the prosecution from using a peremptory challenge to remove a juror who should have been excused for cause. Nor are we persuaded that defense counsel may re-level the playing field simply by requesting an additional peremptory challenge. Our Supreme Court has consistently recognized the type of error implicated here, a violation of the defendant's right to an unbiased jury, as so harmful that it warrants automatic reversal. Structural errors require automatic reversals without individualized analysis of how the error impairs the reliability of the judgment of conviction. The harm arises from a biased adjudicator, pervades and infects the entire framework of the trial. In Abu Namatu L, the citation omitted, and because maintaining the integrity of the judicial process is in the interest not only of the accused, but the public. We are not inclined to infer waiver from defense counsel's failure to use a peremptory challenge to correct the trial court's errors. Reversal is required. When the trial court erroneously denies for-cause challenges to a biased juror, the defendant exhausts her peremptory challenges and the biased juror serves on the jury. This error is structural. The result of the legislature's determination that certain relationships render a potential juror impliedly biased is that the juror is deemed as a matter of law to be a biased period. Such is the cause here. Accordingly, Stouch's conviction must be reversed. Stouch also challenges the court's denial of her motion to suppress evidence from a search of her cell phone. All right, here's the second problem. Because this issue is likely to impact the proceedings on remand, we elect to address it. In denying Stouch's motion to suppress, the trial court acknowledges that the warrant to search Stouch's cell phone was broad but concluded that breadth was necessary. Given the scope of Stouch's conduct after GS went missing, Stouch argues the court erred because the warrant violated her Fourth Amendment particular requirements. We discern no error. So that's not going to stand. The Fourth Amendment protects against unreasonable searches and seizures. The U.S. Constitution amends a search conducted pursuant to a warrant is typically reasonable. However, so-called general warrants, which permit a general exploratory rummaging in a person's belongings, are prohibited. Okay? To prevent a general exploratory search, a search warrant must be sufficiently particular as to enable the executing officer to reasonably ascertain and identify the things he's being searched for. Because cell phones contain so many different types of private data, warrants to search them must be carefully scrutinized. To be sufficiently particularized, warrants for search of data on cell phones must include specific limitations based on, number one, the type of alleged criminal activity, and number two, the identity of the alleged victim, and number three, the time frame, if applicable, within the suspected crime occurred. When evaluating whether a warrant is sufficiently particular, we must look at the totality of the circumstances, reviewing the warrant and any accompanying affidavits in a practical, common sense fashion to determine if probable cause exists. Okay. Even if a warrant lacks particularity on its face, an affidavit submitted in support of the warrant may cure its lack of particularity if the deficient warrant incorporated a curative affidavit by reference, both documents are presented to the issuing judge or magistrate, and number three, the curative affidavit accompanies the warrant during the execution of the warrant. A trial court suppression order presents a mixed question of fact and law. We accept the court's findings of fact if they are supported by competent evidence, but we assess its legal conclusions de novo. Additional facts. The investigating detective sought a warrant to search Stouch's cell phone for the following: data that may identify the owner or the user of the device, address books and calendars, audio and video clips related to the above described criminal activity and further described in this affidavit in support of the search warrant, call histories, call logs, and visual voicemails related to the above described criminal activity and further described in this affidavit in support of the search warrant, photographs and associated metadata related to the above described criminal activity and further described in this affidavit in support of the search warrant, text messages, multimedia messages, recorded messages, and subscriber information and the modules, like the SIM cards, between the cell phone owner and the co-conspirators involved in the above described criminal activity, and further described in this affidavit in support of the search warrant for the above described items. Boy, email messages and attachments, whether read or unread, and related to the above described criminal activity, and further described in this affidavit in support of the search warrant for the above described items. Internet World Wide Web. Browser files including but not limited to browser history, browser cache, stored cookies, browser favorites, and autocomplete forum history and stored passwords. Global positions, GPS data, including but not limited to the coordinates, waypoints, and tracks. Documents and other text-based files related to the above described criminal activity and further described in this affidavit in support of the search warrant for the above described items. Applications and other installed programs, including widgets and any data stored by the application or remotely stored by the application server or database server. Any and all computer software to include but not limited to the operating systems, applications, utilities, compilers, interpreters, and communication programs or any other digital information which can be interpreted by a computer or any related components which may be stored in electronic, magnetic, optical, or other digital forms. And finally, M. Any and all data stored within any computer storage device or the processing and or storage devices to include but not limited to computer applications, image videos, text, programs, encryption routines, and algorithms, or any other data that may be decoded, reconstituted, or otherwise manipulated to produce, utilized, transit, receive, encrypt, encode, or display such images, video text, programs, encryption routines, and algorithms. So they asked for everything. Let's just say this. They asked for everything. With respect to these items, the warrant authorized police within the aid of the law enforcement computer forensic laboratory to view photographs, records, copies, forensically images, and conduct forensic analysis of any and all metadata, programs, and applications on the above described device, as well as any data storage devices or mediums attached or installed in those devices. The warrant incorporated an affidavit detailing GS's disappearance and Stouch's conduct thereafter, including Stouch's refusal to cooperate with police, conflicting statements and behavior, ongoing communication with family members, and social media posts. The client submitted that it was necessary to search Stouch's cell phone to ascertain her past location and communications and to aid in locating GS, who was still missing at the time. Here's the discussion on it. Stouch argues that the warrant to search her cell phone was overbroad because it allowed police to access anything that might be on her phone with no temporal limitations. While she acknowledges that the affidavit was incorporated by reference into the warrant, she argues that it broadbanded the scope of the search even further by allowing the search for anything that could be used as evidence against her. We disagree. The truth, the warrant itself did not describe the type of alleged criminal activity, identity of the victim, or time frame from which the crime occurred, but it specifically incorporated the warrant, application, and supporting affidavit that did. The warrant limited the search to the items specified in the application, and the application in turn attached the 4-page supporting affidavit and made it part hereof. The affidavit described on January the 27th, 2020, Stouch called to report GS missing, stating that he had left her house on foot and had not returned. It continued to describe how, during the subsequent 40-hour period, Stouch refused to meet with police or provide requested information. She was unaccounted for during parts of the day, and GS was reported missing. Called in sick to work for an unrelated reason, and had been continuously communicating with her daughter, husband, and other family members via text messages and Facebook. The affidavit also described that Stouch met with police 2 days after the report, when she substantially changed her statements regarding GS's disappearance. Stouch initially suggested GS went to a friend's house and didn't return. But at the police station, she said that he was abducted by a carpet repair person who had sexually assaulted her at gunpoint. You lying bitch. The affidavit went on to describe a roll of carpet with blood on it that was found in a storage area inside the Stouch's house. It also stated that Stouch's cell phone was linked to her doorbell camera security systems. Based on its specific incorporation of the affidavit, in which was signed by the issuing magistrate and accompanied the search warrant during its execution, we conclude that the warrant was sufficiently particular. Stouch argues otherwise based on Coke, which is another case, in which the court found a warrant was insufficiently particular because it contained no limitations as to the alleged victim or time period during which the crimes occurred. But as described above, the warrant and the affidavit were specifically described. Oh my God, don't do that. I just heard that. Okay. Okay, hang on. The warrant and affidavit here specifically describes Stouch's conduct during the 40-hour period after GS went missing. Okay. Then it says, cell phone warrant was sufficiently particular because it incorporated affidavits describing investigation. While the warrant was broad and the affidavit was specified, it described conduct limited to those 40 hours, clearly identified GS as the victim, and detailed inconsistencies in Stouch's conduct and story in the aftermath of his disappearance. The fact that the warrant was broad was not dispositive. When it covered a 6-month period, the affidavit identified the victim and specific crimes, and the defendant's conduct and communications surrounding the crimes were relevant to identifying him as the suspect. Okay. Him or her, really. Moreover, many of the categories described in the warrant were expressly limited to items related to the above described criminal activity and further described in this affidavit. While not every category includes the same limiting language, the warrant's incorporation of the attached affidavit serves as the same function. Okay. Warrant satisfied particularity requirements on the basis even if it could have been more particular. That's good. Because the warrant and affidavit read together limited the search of Stouch's cell phone to a specific time frame, victim and type of criminal activity, the warrant did not allow for general search. Instead, it targeted a specific set of data that allowed police to establish Stouch as a suspect. Okay. Um, a broad search warrant, nonetheless, permissible when the requested evidence is justified by the nature of the crime or crimes. We therefore conclude that the Fourth Amendment particularity requirement was satisfied, and Stouch's motion to suppress was properly denied. Thank God. Okay, so disposition. The judgment is reversed and the case is remanded with directions. Oh my God. I hate it. And then Judge Bernard. Go ahead. I'm listening. Yeah. You mean Colorado? Colorado. Mm. Hey guys. Oh, hey guys, I was reading. I did notice you in here. Thank you for stopping by. We really do appreciate it. This was just a last minute thing. Sprinkle notified me that, oh my God, they made the decision and it was reversed and it made me sick. So I decided to jump on a live real quick, read aloud why they reversed it. And we are happy to say at least they did not throw out the evidence from the cell phone. That is so needed in the retrial. So, yeah, thank God. Thank God. All right. I can't stay on long. Go ahead. Yay. All right. I can't stay on long because I have a 1 o'clock appointment, but I wanted to jump on, get this information out. Just remember, you heard it first here. That's right. Letitia Stouch overturned only because of juror bias. All other evidence will be represented. And I just want to say, I feel so bad for that family. I also feel bad for Harley because she's got to relive this now and she has to retestify now. And she's moved on with her life and done a beautiful job. But here she is being pulled right back into it because of a juror bias problem. I love Judge Warner. I wish this wouldn't have happened. I still respect him. I still love him. And we'll talk to you guys later. I got to get going. Thank you for stopping by. Please hit that like button on the way you're in or the way out. And as I always say, yeah, I need to change the name of our live. I just quickly threw it on there. And anyway, as I always say, please take care of yourself. Be careful out there and take us out, Sprinkle. That's right. Life is short and our time with them is even shorter. That's right. So we'll see you guys later. Have a good afternoon. I might come back tonight. I'm not sure. See you guys later. Have a good day. Bye.